Ready, start. Similarly, PW4 claimed to have seen the appellants together on the evening of 5/6/2007. However, his statement finds no mention in the FIR and upon scrutiny suffers from internal contradictions. Counsel submitted that this omission in the earliest version, coupled with inconsistencies in his deposition, undermines his credibility. On these grounds, the council contended that the High Court's assertion that PW3 and PW4 were double inverted comma natural witnesses double inverted comma close and their statements double inverted comma inspire confidence double inverted comma close ignores these deficiencies. Learned counsel for the appellants also challenged the evidentiary value of the rope and axe. He pointed out that the recovery was at the instance of the co-accused Arman Ali. It was only during the pendency of the appeal before the High Court and at its direction that the rope, axe, and clothes were forwarded to the Forensic Science Laboratory for examination. The FSL categorically reported that no complete DNA profile could be generated from the exhibits and therefore no match with the appellants could be established. Counsel stressed that this was the only scientific evidence available in the case and far from supporting the prosecution, it failed to implicate the appellants in any manner. He submitted that both the trial court and the high court ignored this crucial finding, even though it directly undercut prosecution's case by treating the inconclusive DNA report as insignificant. The courts below overlooked the settled principle that when scientific evidence tilts in favor of the accused, it cannot be brushed aside. Counsel further underscored that the X was not initially sent for forensic examination at all. This lapse, according to him, revealed a serious flaw in the investigation. He submitted that the failure to subject a key alleged weapon of offense to scientific analysis at the appropriate stage amounted to defective investigation and deprived the prosecution's case of the corroborative support it ought to have provided. Counsel also referred to the testimony of PW8 who conducted the post mortem. The doctor opined that the cause of death was strangulation and that the injury could have been caused by an axe. However, he also noted that a blunt object had been inserted in the anus. The appellants were acquitted of the unnatural offense, and counsel argued that the medical evidence does not by itself link the appellants to the murder. He contended that the alleged motive, that is, revenge for an insult to the sister of one of the co accused, is vague and unproven. In a case involving circumstantial evidence, the absence of motive weighs in favor of the accused. It was further submitted that both appellants Najim and Aftab were juveniles on the date of the incident, as evidenced by their school records and the report of a medical board. The Juvenile Justice Board rejected this claim based on an electoral roll. Appellants submit that this contravenes Rule 12 of the Juvenile Justice (Care and Protection of Children) Rules 2007 within bracket hereinafter referred as double inverted comma JJ Act double inverted comma close bracket close. Even apart from juvenility, counsel submitted that the High Court failed to reappreciate the evidence independently.